Hey, it's Ahaji of Ahaji MSP LLC. I am a small business attorney. I represent entrepreneurs, solopreneurs, small, medium-sized businesses. I'm registered to practice before the U.S. Patent and Trademark Office, and I do a lot of patent and trademark applications for my clients. Today, we are going to be talking about trademark searching. I've defined trademarks 1,000 times. If you want a definition, you can go watch another video. This video is just going to talk about searching, so I'm going to assume you know what a trademark is. So if you understand trademark law even a little bit, you know that it's really, really important to do a search. You don't want to invest a bunch of money in trademarks or in branding, materials, banners, websites. You don't want to invest all that money until you know that you have a legal right to use that trademark. You don't want to get sued. You don't want to get a cease and desist letter, especially at the beginning when your funds are pretty tight. You want to make sure that you use your money where it's going to go the furthest. Excuse me. So we want to make sure that that trademark is going to be available for you to use as a first step before we file that trademark application. There are lots of different types of searches. I encourage you, if you're looking for a patent and trademark attorney, that you make sure you understand what type of search is included in the fee. There are very few reasons to do a comprehensive search that costs thousands and thousands of dollars unless there's a particular indication for it. For most people, what we call a knockout search is going to be enough. Knockout searches, we're really looking for a really close or direct hit on the trademark. So we're looking for something that's very obviously confusingly similar or something that's going to dilute a famous mark that we know about. So you want to make sure that you do this search before you file an application. So as part of my trademark how to file a trademark without an attorney class, I walk the students through how to conduct a proper search. And, I let them, and I'm going to let you know, that in order to conduct a proper search, you need to make sure that you're looking in all the right places and that you are using all the right search terms. That's probably the most important thing. And no matter how good you search, I can guarantee you that the trademark office is going to find something out there that you didn't find, and they may find things that you found and you dismissed that they think are important. Don't think that if you do a search, that means that your application is just going to get a stamp of approval when you send it in. That almost never happens. And in fact, when it does happen, most attorneys think that we've done something wrong. We actually want the trademark office to do a pretty good search. So, today I'm going to go over 5 considerations when doing your own trademark search. So you want to think about these 5 things. These are the biggest mistakes that non-attorneys make when they're trying to do trademark searches that lead to problems down the road. They come to me and they say, oh, mine is completely different, or how could this come up, and why are they talking to me about something in a different industry? So we're going to go through those 5 problem areas when it comes to searching. The first one is where you search. A lot of folks are going to immediately go to the USPTO's website. I have a video on how to search on the USPTO's website, but I want to make sure you understand that that's not the first place you look. Trademark rights begin when use begins, right? You've heard me say you can't enforce it, meaning you can't prevent someone from using your trademark until you actually have a registration for it, but your rights begin when you actually use it. So, although you are going to search the USPTO's website, it's definitely not the first place you want to look. The first place you want to look is actually Google, or whatever your favorite search engine is. If you like, I don't even know if they are, Fire, whatever, Safari, whatever it is, whatever your search engine is that's going to search the whole web, that's where you want to go. It doesn't have to be Google. It can be something else. Internet Explorer, if that's what you want to use. So you want to do a search on one of those search engines, and you want to make sure that your search is very broad. You want to search names, URLs, social media handles, email addresses. You want to check the names of businesses with the Secretary of State. You want to make sure that you are checking every use of it, because it just needs to be a commercial interstate use out there. It doesn't have to be any specific type of use. It doesn't have to be an advertisement. It doesn't have to be a name of a product. So you want to make your search as broad as possible, which is why I tell my clients the best trademarks are completely made up words. Yeah, the marketing agencies are going to tell you, go with something descriptive so that the customer immediately knows what your product is, but that's not going to get you strong trademark protection. Strong trademark protection comes with words that are completely made up, because then you eliminate all the arguments that the trademark office has about being descriptive and generic, and you can also ensure that no one else is using it because you made the word up yourself. So the next place you want to search is obviously the USPTO, right? Because it may not be on Google or whatever. You may not be able to find it, because my guess is that so much information is going to come at you that it's going to be really hard to filter through. So you want to go to the USPTO's website and you want to do a search. If you want to know how to do that, check another video from me, and I can walk you through that process of doing the search on the USPTO. But you want to do a USPTO search. And I do want to point out that when you do a search of the USPTO, do not limit the class. Don't limit the class. You want to do a generic search of those key terms in the mark. If it's a word mark, if it's a design mark, then you want to find the codes for those elements. Again, that's a whole separate video, but you need to find the codes for those elements that are within that mark. The codes for circle and triangle and that sort of thing. And you want to make sure you do those searches, but you don't want to restrict it to a certain classification. It's actually pretty important. All right, so another common mistake is that people, when they're doing searches, don't realize that you don't have, in order to infringe a trademark, you don't necessarily have to infringe or use the exact terms or the exact logo. So it's confusingly similar. That's the standard. If the mark is or the use is confusingly similar to the trademark, then you have an infringement. So when you're searching, you want to use common misspellings. So, Google it and then see which misspellings pop up. So you want to Google all the misspellings and iterations. You want to break the word up if it's a compound word. You want to add and delete punctuation, things like that. So you can see any changes to the mark that are really minor that would confuse the consumer. You want to use homonyms. You even want to try synonyms sometimes. When I'm doing a search, I'll try synonyms, but definitely homonyms. If it sounds alike or it looks alike, then that's enough to confuse the public. You've seen products out there that are trying to steal customers from from a larger brand, and they'll make their packaging really similar but not the same, and they'll make their wording really similar but not the same. Those could still be infringements because we're looking for a confusingly similar look. Now, with that being said, you have to pay attention to foreign translations. So you can't simply call water agua and say, hey, I'm in America, we speak English here, and so, that's my trademark. Well, no, because agua means water, so that won't really work. The Patent and Trademark Office's software is going to translate your mark, if there are words in it, to a bunch of different languages. And so you need to make sure when you're doing searches that you're going to search for at least the common languages that we're used to. So you want to use that, Google Translate or whatever app you have to see if there are going to be other words that mean the same thing in different languages. You also want to make sure that those trademarks don't mean something disparaging or something that is potentially not able to seek trademark protection for various reasons in a foreign language. I've had a client before who wanted to register a trademark, and the word really didn't have much. It wasn't disparaging or offensive in English, but when you translated it to Spanish, it was very disparaging. And I mean, it was basically a slur. And so we were not able to get that trademark for him. He kind of, I think he knew it at the beginning. And I told him at the beginning, he's like, no, but that's not what I'm talking about. But as his website developed and his product line developed, it was very clear that the racial slur was intentional. And so the trademark office picked up on that, and we weren't able to get the trademark for him. So don't make that mistake. And the last mistake that people make is they search within the class. So yes, it's true. A trademark only gives the registrant protection in the class in which the mark is registered. So it's the class in which the mark is registered. So if you have a trademark for Canon and it's registered for digital and mirrorless cameras, then you can only stop people from using Canon for digital and mirrorless cameras. You can't go beyond the bounds of the trademark registration. The issue is that there's a doctrine called dilution. And dilution says, even outside the bounds of my trademark, if another use of that word is going to dilute the public's perception of my trademark or dilute the strength of my trademark, which is, of course, based on public perception, then that is also an infringement. Let me give you a very clear example. A famous mark called McDonald's. So McDonald's has the McRib, the McChicken. In other countries, the McPork. I've seen the McEverything. McDonald's does not sell clothing. However, if you put McShirt on the front of that shirt, the perception from the public is going to be that that shirt was purchased from or distributed by McDonald's. If you call this cup a McCup, you're going to think the same thing. That cup must be associated in some way with McDonald's. McDonald's is a famous mark, and famous marks have greater protection than ordinary marks. So as a famous mark, McDonald's can pretty much stop anybody from using McAnything to describe almost anything, under the auspices of, if they do that, they're going to dilute my mark, and my mark is not going to be worth as much. My mark is really strong, it's famous, and I deserve a little bit more protection. So I hope that helps. Those are the 5 most commonly made searching mistakes, and I think you can avoid them and come out with a really good search. You can search more like a patent and trademark attorney with search. And I hope that helps you. My contact information is going to follow. I would love to help you. If you want to learn more about searching, there's information below in the notes about the trademark registration class when we cover searching in that class. And I'll also, put some links to other resources that can be helpful. Alrighty, happy searching.